That's how it
Okay, welcome back, fathers, archbishops. So it's good that you have so many contributions to make by way of your questions and clarifications. I am very happy. Very happy about it. Some of the things I do not know the local context. As I said, one principle is that you have some policy regarding dealing with some of these things, but I mentioned to you the mind of the church. For example, that's what one of the things the Holy Father is. Man-made law cannot be the same for all ages, for all places the same. Thou shalt not commit adultery, no dispensation possible. 10 commandments, no dispensation is possible. There are situations and situations. Back in 1992, I was doing my holiday ministry during the summer in Germany. Those days, and before that I was in one of the parishes. Now I feel how the law can change. For example, just to give an example, when I was assistant priest in one parish called Video in my diocese, I was asked to beat the small children who were studying 3rd standard for not coming for daily mass. I was beating actually. Now I feel very sad. Weekday mass on a Tuesday or Wednesday, the mass at 4:45, 5 o'clock. It was still dark at that time. But then all Catholic children must daily come for mass. Not in boarding children, they will come. But in the village, maybe 1 kilometer away walking, it was so strict. It was so strict. Now I said, in Europe, the so-called Catholic countries, Christian countries, even Sunday Mass, people don't come for days together, and then we never dealt with them harshly. But I dealt like that. Then I was parish-based in one parish in 1989. There, one boy married, had relationship with a girl. The girl became pregnant before 18. I cannot rectify the marriage according to the government law that I am recently changed by Moraj Desai. Then I was one of the parties together with the village heads to decide, so uncharitably to decide that the girl and boy should be out of the village till they reach 18. Girl reaches 18. So strict, and nobody opposed it. They said it is normal. How can it be like that? You can't rectify the marriage also. How can you allow them in the village? It is scandal. Others will follow suit like that. When I went to Germany in 1992, 4 weeks I blessed the marriage solemnly, solemn mass in German, together with the baptism of the children only. Back home I was thinking, I call it rectification. Here I am, parish priest asked me to celebrate solemnly mass with choir, dinner and things like that. Already in 1992 in Germany it was like that. What we call rectification, in the West people call, finally they have at least come for a church marriage, after 10 years. Thanks be to God, they will say. Thanks be to God. So, man-made laws are always subject to change. That's why the whole code is also now almost changing and changing. So many changes are there. Now 21 canons at this stroke. Then afterwards, to make them agree with the Oriental code, so many canons are changed also. And before that first change came with regard to some fundamental truths which are taught by the church emphatically. Regarding that there was change. Now by next year, the whole book 6 will be changed. Whole book 6 will be changed. And the whole book of the code, 6th book will be changed by next year. It was kept in cold storage, again it will be changed. So I asked our TPI, which functions in our campus, in which I am also one of the members for 7 years. Now I completed. So not to reprint the code, because the whole code is going to change. We will have man-made laws can always change according to the circumstances
and then times and all. But what is important is ultimately all law help the people. It should not be too rigid. Too rigid. Finally, the salvation of souls. Teaching about dispensation, why I always asked, the other day I asked the MCL fathers, law, everybody must follow now? Yes, everybody must follow the law. Purpose of law, salus animarum, suprema lex. They say, okay. But then why dispensation is given? A person is relaxed from the obligation of law in a particular case, then I expect them to say, in certain situations, observance of a man-made law may be more harmful to the salvation of soul than non-observance. So when there is a just and reasonable cause for the spiritual welfare, the competent authority excludes a specific person in a specific case from the obligation of observance of the law. That's why we have the whole institute of dispensation, giving exemption from the obligation of following a man-made law. Certain things cannot be exempted. Yes.
Father, who decides?
Yeah.
This is a man-made law or this is a divine law?
Divine law we know from the Revelation, from the Bible, yes.
As a Catholic,
All other things are.
I'm talking about as a neutral person.
Yeah.
As a Catholic, I
Yeah.
follow it.
Yeah.
But otherwise, who decides? Suppose a non-Christian, a non-Catholic, divine law and
Yeah,
man-made law.
that needs catechism, instruction and all. See, we have studied in your moral theology right from the beginning. Divine law can be divine natural law, divine positive law. Divine natural law, insane person cannot marry. Divine natural law, insane, because he is non sui compos, he is not responsible for himself. Impotent person cannot marry. Divine positive law, the 10 commandments, divine positive law. What we have seen like that from Revelation, from the very nature of things. That's how we have studied and that's how we have to follow. Okay, leaving that aside, now I want to introduce to you the new doctrine. As you know, it is the fruit of 2 synods. The 3rd extraordinary synod and then the 14th ordinary synod. 2 synods were conducted in 2014 and 15, no? Or rather 2013 and 14. 2013 and 14. 2 synods, the fruits. The synodal fathers were very much concerned about the family crisis, healthy families, the domestic church. They were very much worried about it, what is going on. Especially one of the concern is pastoral care of them. And one of the concern, more than in our country, in the West is, some time back they were saying one marriage out of 3 is broken. And then 1 marriage out of 2 is broken some 10 years ago. Now 2 marriage out of 3 is broken. So already practicing is between 10 to 20%. 20% very high. 10% is normal in some of the Western European countries. And out of those 10% who come, then there are 7 divorced and remarried. Only 3 can receive communion, means what can happen? Like that, it is the problem. And they are so much interested. They were discussing badly with this idea, and it was a real problem. Maybe my numbers are a bit exaggeration, but still you understand the overall situation. So how to be, they were very much sick. One of the things is, the focus of the synodal fathers was how to rehabilitate people who are in canonically invalid marriages. A marriage may be in fact invalid. This is one problem, big problem. A marriage may be in fact canonically invalid. As I said, those 3 points. So, no canonical form, there was an impediment, and finally, most important, the consent, there is some defect. Invalidating element is there in the consent, in fact. But it is, though they jure invalid, it is not a declared invalid. It is not a declared invalid by the church. Though in fact invalid, it is not yet declared invalid. Why it is not yet invalid? One of the reasons is, one is fault of the pastors, did not prepare them properly, did not help the parties to approach the tribunal, and part of the faithful themselves, they were not worried, they didn't bother, okay, doesn't matter what happens, like that, they simply live. So how to do like that? In this situation, they said, again and again the tribunals were asked by the fathers to be more accessible. Secondly, make the process faster. So this was the concern which many fathers of the synod expressed. So, be more accessible. So one of our fathers, Father Stanley Kumar, used to say, some are available but not approachable. All the time fighting, shouting, this and that. Some superiors of the religious congregation also will say, I'm there, no, why can't you tell me? They experienced already, once they told her, that's all, end of it. Why did you knock at my door? They will say. Available, not approachable. Some others are approachable but not available. Very kind person, not approachable only. My colleague, Father Y. Irdiraj, senior canonist, I collaborated with him for the translation of the whole code of canon law into Tamil. We have a Tamil canon law also. Most of the work done by Father Y. Irdiraj, myself, and Father Alex. We three of us only did the translation of the code into Tamil. So he was complaining to the bishop, I am judicial vicar, I am also teaching in the seminary, I am parish priest, you have not given me any assistant, like that. Then the bishop said the next year, now there are a few ordinations, I give you 2 assistants. And the 2 assistants were 2 extremes. One was always glued to the TV, cricket match. Father will call him, he say, headache, Father. The other assistant never comes to the room only. You cannot see him only. When bishop during the confirmation pastoral visit, he asked him, Father Y. Irdiraj, are you happy now that you had no assistant last year, now I gave you 2 assistants? He said, your lordship, you gave me 2 assistants, but one has take-off problem, the other has landing problem. So some of the parish priests has take-off problem, they will not go out, but still it is as good as they are not, they never come out of the room also, that can be also. Some others we never find them, they are like visiting professors, visiting parish priests. Visiting parish. So they should be accessible. So this way, that's why right at the beginning we spoke about airport bishops. Now priests, availability, parish priests. Canon, see sometimes I wanted to translate the code because people should know their rights. When I go for lay seminar, some priests are afraid they will ask me more questions. Don't teach them canon law. 529, is it so, Father, it is given? They will remind the people of their obligation. 529 para 1 says, all that the parish priest has to do to the poor, to the sick, to the abandoned, to the dying, everything is described. These are the obligations with regard to the pastoral obligations of the parish priest. Sometimes we do not do all this. So they should know. Accessible. You should be accessible, it should be faster. Justice delayed is justice denied. Justice denied. Say for example, a girl got married late. Say at the age of 32 only she got. In some of the western countries and all, it's quite normal. Here maybe 25. Even now, somebody who is studying doctor to become a doctor, then she wants to finish MD also before. Then only they start searching. By the time she is 32. And then marriage failed in 2 years or 3 years, 35. The judicial vicar takes another 5 years to deal with the case. And the poor woman has no joy of having children. Only adopt. Only adopt.
only adopt children, you see, not too much delay. The marriage should be basically like that. The Holy Father spoke of some of these concerns in the document. What are the things? The first one is one major change is formerly they wanted to be doubly sure that the marriage is really invalid. So when the diocesan tribunal or tribunal of first instance declares a marriage invalid, it must be confirmed by the metropolitan tribunal. Metropolitan tribunal. The second instance tribunal is necessary. Even if it is interdiocesan, who was your second instance, Father Padurai, for you? Second instance? Bombay. So every marriage that is annulled here should be done. The Holy Father said no need. So how long? People already waited here so long. This is one of the major innovation, novelty that is brought in. No, hereafter, from December 8th, 2015 onwards, no need of any going back to the second instance automatically. If the parties appeal, okay. Otherwise, there is no automatic sending to the second instance. So people are already suffering, you are declared invalid. So, no, that is the first point. Okay, I will finish afterwards, you can ask some questions. Secondly, formerly, the code itself said, any marriage nullity case, in principle collegial. By way of exception only single judge. By way of exception only single judge trial. Now, it is not necessarily an exception, single judge, and it is not possible you can. For having single judge tribunal, you have to get apostolic signatura's permission formally. Now it is not like that anymore. The bishop can decide, not enough canonists. A single judge can always deal with the matter in the first instance tribunal. But for validity, second instance always collegial. But first instance single judge is enough. Another major change is Canon 1421 2 spoke about lay judge. Lay judge can be in a college. If there are 5, there can be one lay judge. If there are 3, there can be one lay judge. But now, the Holy Father said, one who presides must be a cleric. But even if you have 4 lay judges, no problem. Even if you have 2 lay judges, only 1 cleric, no problem. So to make it more, in our context, very few people are qualified in canon law, some sisters. So suppose 2 sisters are qualified in canon law, the second instance tribunal, they can be 2 of them here. But the presiding judge must be a cleric. Still the church is hesitant to allow the lay judge as the single tribunal. That is the second point. An opening here with regard to collegial tribunal where there could be only one. Now majority also can be lay person provided the presider is the cleric. Presider is the cleric. That is the second point. Then another important point is the one which is raising a lot of controversy, the brief process. Before I go to the brief process, I want to deal with the other thing is, I said it should be more accessible. So especially in the West and all, the tribunal fees was too high. Now, so because of that, some people did not want to come to the tribunal. What about this church, this faith and all? So now, in principle, give it free of charge. In principle. But if the people are able, you can get from them. Secondly, if the diocese is unable to give free, let the Episcopal Conference help. Let there be a fund to be set up. If they are giving, okay. So why? Because the Holy Father wants it to be more accessible. Episcopal Conference is asked if a particular diocese finds it so hard to meet the expenses of this. So please help them also. So like that. This is also to make it more accessible.
because of economic criterion, let not the people live in sin. But it is another matter, people spend for this, like that. When it comes to a church, they don't want to give. That is also a problem. One father was blessing a marriage in one of the parishes of the city. He took auto and paid some 300 rupees to go and celebrate the mass. He was so upset. They had 2 or 3 video cameras, everything solemn, but then they gave him only 250 rupees for the mass time. But he was so upset. I spent 300 for the auto fare, but then these people, if they are poor, I can understand they are not giving. We have to also encourage our people to contribute. But then you may contribute, get from the petitioner, but to get from the respondent sometimes very difficult. Very difficult. But both of them are asked to share the expenses. But then the Holy Father in this Mitissio Lex Dominus says, see to it that as far as possible the tribunal fees are condoned and then they are rendered free. This is service. Don't equate it with other services that you do. Encourage the people that let them come and rectify the man. That is in principle. But still you can get something according to their experience. But if they are really poor, let them not be too much burden like that. So more accessible in this way. With regard to coming to foster cases, I was telling you already there was the foster case. One thing the Holy Father affirmed, even now I stand by the judicial process in accordance with my predecessors. Not administrative process. So I want the marriage cases to be dealt with judicially. Why? Because to protect the bond. Judicial process takes longer, but it is certain to protect the bond and establish the truth. Administrative is faster, but then sometimes there is danger of error, making a mistake. So I have not changed that marriage case. We decided judicially. Though many non-Catholic Eastern churches do administratively, I too stand by it. I continue with the same thinking. But then this judicial process must be expedited, must be made fast. Must be made fast. Don't delay it. So for that, so many marriages may be alleged to be invalid. You may allege a marriage to be invalid. But all marriages need not be decided in the same way, the nullity. Some you have to follow the ordinary process, some speedy process. Some. So in this context, he once again emphasizes the bishop is the head of the diocese. They should have a personal role in the adjudication of some of the marriage cases. So you might have studied Canon 381 says about the power of the bishop. So from a system of concession, we have moved to a system of reservation with Vatican II. Earlier theology was everything is that of the Pope. In some cases he gave concession to the bishop to decide. But Vatican II said, especially Christus Dominus said, so the bishop must be given all the necessary powers to govern the diocese. Only in some cases certain things can be reserved to the Pope. So he uses a number of words. Ordinary power that is attached to the office, proper power, Canon 381. That means he exercises in his own name because he is vicar of Christ. Vicar of Christ. Not only Pope is the vicar of Christ, each bishop is the vicar of Christ. And then immediate power. That means he can exercise directly, even without mediators. The three adjectives used in Canon 381 to describe the power of the bishop. Sometimes he has to use mediators, intermediaries, okay, because of his too much of responsibility.
So Canon 391 speaks about the power of governance of the bishop. It speaks about legislative power, which he has to exercise personally. Executive power, which personally or through BG or episcopal vicar or other priest. Then judicial power. The bishop is the first judge of the diocese. First judge. He exercises it either personally or through judicial victor and other judges. Judicial victor and judges. So what the Holy Father wants to remind them, you are the judge of the diocese. So certain things, as it was in the history of the church, you have to deal with it, have concern for it. So what you have to do, judicial vicar and judges, let them write the ordinary process, let them deal with the ordinary process. But then the bishop should pay special attention to the speedy process, where the marriage is apparently null for all practical purposes. The Holy Father gives a number of cases. In this case, it is null. Some of which we did by where it is impediment was there, canonical form was missing. We were doing by the documentary process. Even in the case of consent, don't treat all cases in the same way, where consent can be vitiated. For example, the woman went for sterilization before the marriage. There is a certificate. This is cheating, deceit. So why should you wait for 2 years, 3 years for the tribunal to finish the case? Complete cheat. They know about it, and then they have got proof. The other party brings, see, on such and such a day, she did pubectomy in this hospital. I never knew it. Why do you take the whole thing? So in such a case, you can finish the matter if it is like that. Do all this, decide the ground and all. The judicial vicar decides this is a case very apparent. Nobody can contest it. And so he gives a whole list of the things which are such possible cases which can be taken for. I don't want to go in the detail of all that. Especially he speaks about where there is no faith at all. A person has no faith in marriage, simply came through, never believed, never came to the church. In this case, the person simply came next day, suddenly went with some other woman, finished like that. Some of these cases, it gives a whole list of things which are very, very clear. The consent is vitiated. So in a matter of 45 to 50 days, this can be done. But of course, the judicial vicar has to do the bulk of the work. But the question often raised is the bishop competent to write the judgment? If the bishop is expert in canon law, whether the bishop is expert in canon law or not, bishop is the judge. He has to be helped by the canonists or other people who are knowledgeable about it, and the judicial vicar must decide this case deserves a faster process, and then tell the bishop and do the speed work, and finally these are the things, discuss the case, at least for some time involve the bishop. And though it is expected bishop writes, in most of the cases the judicial vicar may be doing the bulk of the work and bishop will sign, seeing that this is a very clear case. Don't prolong it for too long, that is it. Now, suppose the judgment is over, within the prescribed time the person has not made an appeal, then the parties are free to marry, no need of going to the second instance. So far we never made a distinction with regard to invalid marriages based on improper consent. But now the Holy Father says, based on improper consent, we can distinguish some which can be declared invalid fast, others which cannot be declared, which have to go through them. In this context, one important point the Holy Father says is, the cases must first come to the parish level. I mean, it is suggested, not mandatory. Parish level, family commission or group, whatever you call it, they have to do it first. They have to screen it first. Or at the diocesan level, family commission or a commission, call it whatever by name. So far, these people in difficulties, One thing is preparation before marriage. One thing is afterwards when they are in situation doing like that. They have to go through it and even they can give their report to the judicial vicar and to arrive at whether it deserves fast or this one. So they encourage even at the episcopal level, conference level also, they are asking such kind of committees should be there, diocesan level or deanery level or this one. It is a very, very strong recommendation that first these cases are done by them. One of the things when we send the annual report to the Apostolic Signatura, they were always asking 50 cases, 48 null. Only 2 cases not decided. No cases said marriage is valid. They were always honest. Why no cases? Then my own colleague Father Vayadhira will say, are we fools to take up a case which is valid and then go on for 1 year like that? That's why like that they will say. But then now the Apostolic Signatura will not ask such question hereafter. Hereafter they will not ask the question because already they expect us to screen it at 2 levels. They screen it at 2 levels. Only when there is possibility they will send it. So they will not, the judicial vicars will not be asked why you are not giving no judgment like that. Hereafter, I am sure they will not ask such.
Judgment in favor of the bond.
Yeah, judgment in favor of the bond. If we don't give, they will not question. They will not wait. We call it affirmative judgment when it is null. When the marriage is null, we call it affirmative judgment. Okay. That is the thing. So this level can always help, not only in the preparation for marriage, but even in assisting those people. Then to whom they will appeal. Suppose the bishop has decided. So individually, bishop has written the judgment, at least signed the judgment. So they can appeal to the metro. One of the things is go to the power of the metropolitan is re-emphasized. Ecclesiastical province is important. Always go to the second instance. So in this case, who is the metropolitan? So the archbishop. If it is diocesan tribunal, to the metropolitan tribunal appeal. If it is archdiocese, where to appeal? Then it simply says senior suffragan.
For all other cases, senior suffragan means that bishop who is senior by promotion. That bishop who is senior by promotion. So for this now the Holy See has given a clarification. The senior suffragan is not dependent on the bishop. The senior suffragan is suffragan diocese by its election. Suppose which diocese was a permanent basis, that senior suffragan, otherwise senior suffragan means once one bishop will be senior bishop, then another time another bishop will be senior bishop. So not provided, permanently the senior diocese after the archdiocese. Seniority by its establishment. So that bishop will receive the appeal if there is an appeal, if at all there is an appeal. One thing I forgot to say, for this speedy process, both the parties must agree, or at least one agrees, the other gives consent. Only then you can take it. One party gives the petition, my marriage is invalid. The other party also agrees. That also now authentic interpretation has come, answer has come. If there is no consent of the other party, you can't take it for the speedy process. You cannot take the case to the speedy. Both of them alleging it is invalid, or one alleges, the other has given consent. The other is saying, no, the marriage is valid, means you can't take for the speedy process. These are especially some of the things that are mentioned with regard to this process. Yes.
Two parties apply.
Yes.
Two parties apply.
I will go to that.
Two parties, both husband and wife, applied different petitions.
Yeah.
But what other parties are not in the country. It's out of the country. Then, in this case, how to hear that?
Yeah.
I mean, speedy process is possible by the very fact both apply.
Yeah.
But what the applicant is not present here? How to proceed in this case?
Yeah, just as the usual case by rotation. That is one basic law. Every tribunal must help the other tribunal when it is called upon to do the investigation.
Here is a speedy process.
Yeah, speedy process, they can send it like that, as far as possible within 1 day. Otherwise 2 days, 3 days also okay. But then get it also, the other party is not able to come from the other country, call the other tribunal has to do all these questions for which you want to ask, and then you have to finish. Same thing, but then don't take too much of your time. Speedy process means not that all the hearing should be, as far as possible, make it within that week. But then if it is not possible and the person is away, then you have to use the basic right of rogation.
Rogatory even in this case.
Yes, even
But who will be with the rogatory? Is it the local ordinary?
no, on the authority of the judicial vicar. Judicial vicar only instructs most of the thing.
Correct.
And then finally the judgment is supposed to be by the bishop. Yeah. Okay.
Thank you, Father.
Okay. Yes, Father.
What is the role of the family commission in the parish level or the diocesan level?
Yeah.
How can they, what's their authority? Once can they recommend it to tribunal?
Yeah.
In this case, okay.
Okay. First of all, their authority is not judicial. Secondly, it is only consultative, recommendation, preparation for carrying it out. Suppose the family commission also may be not doing sufficient work, they may simply recommend everybody this, not. They have to be serious-minded people who can give us the necessary background, real documentation in some cases regarding the history of the marriage, those who prepared for the marriage. That's why the Holy Father speaks about those who prepared the marriage, the parish priest himself, all their documentation, all their attestation will really help in the process. Let them not think that they are an intermediary authority, it is only consultative. Suppose they say no also, still the parties have not lost the right to approach the tribunal. Some of them, one parish they are really good, another parish they don't bother about it at all. But ultimately, this is only a help for the tribunal, for the bishop to really deal with the case effectively and fast. Yes.
I'll take 1 minute just to give an example
Yeah.
of what Father was just asking.
Yeah.
I approached the tribunal 3 years back.
Yeah.
The case, the woman is in the States.
Yeah.
And then we had this problem that she's there and all those things where we'll get the witnesses. So she said, all right, she contacted the parish priest there and the tribunal, bring the case here. So she took it there, she's there itself, and in no time, I wouldn't say
Yeah, correct.
department, it's the marriage annulled.
That's why one basic thing, one tribunal is obliged to do. If they are not assisting us, they are disobeying the canon law. Correct. Okay. Thank you, Father. Yes, Father.
Is it necessary in all the cases before church annulment, the party is compulsory to get civil divorce? One. Second, when one party is paying the fee, already Pope said, as far as possible, make
Yeah.
it free.
Yeah.
One party is paying the fee, other respondent, the party doesn't want to pay. Can the judicial vicar press the party, forcing that if you pay money, I will accept it?
Yeah. I will give my opinion. For the second question with regard to the fees, I told the mind of the Holy Father. Make it as far as possible free. Forcing it so I will not give you a judgment, according to me, may not be right. If you don't pay, I won't give the judgment. That's my opinion. Okay. To the first question, so I already explained to you with regard to the new marriage, both civil divorce is needed and first of all annulment is needed. So there are dioceses which insist that you come with a judicial civil decree, only then I will accept the case and like that. There are many dioceses in the country. When I asked them, they explained the practical problem because sometimes they ask us to bring the whole file there from the civil pressure, all this. Though we say this this doesn't have any civil consequences, they have so many things. Sometimes, in civil law, there is no possibility at all for obtaining a divorce. Even in that case, still they want to do with us like this, some reasons they are saying like that. But then, by the general law of the church, it is not prescribed as a prerequisite. I should be honest about it, that only after getting the civil divorce, my own opinion would be, if there is no problem, you have to go side by side, because civil divorce so many years, as I said in that case, civil divorce takes 3 years. After these 3 years, it can go simultaneously. If there are specific problems, the bishops have to advise regarding this policy. But I do know, as you said, that there are dioceses which say that you can first get this. One thing is to discourage the case. Another thing is that less number of cases, already so many cases, they are also coming like that. But canon law itself does not make it mandatory. Without getting civil divorce, you will not. That is the general law. So we have to be clear, but we have to do it fast. If it is civil divorce can be got 1 year, then you don't take so many years again. Already they wasted 1 year because of you. So that we have to understand. Okay. Yes, Father.
Is there any time frame for this process?
For the process. See, the old law said the first instance must be finished in 1 year. I know old law means 1983 code, the present code itself. 1983, 1 year. The second instance, it has to be at once confirmed. It only said at once. But if it is second instance ordinary, 6 months. But I have never heard of 1 year finishing. Many dioceses, 1 year also never finish the case. Some judicial vicars and judges solemnly keep the cases as long as they want. They are, not only they are celibates, they make married people compulsory celibates. Married people compulsory celibates and keeping. You may sleep because you make the promise of celibacy at the time of ordination. And you are encouraging people, at least give some answer, even if it is negative. Let the person at least go to the higher court or go to the Roman rota at least. But then that is the thing, the tribunal thing is was not considered very serious, and then earlier itself. Now the speedy process, according to what Cardinal Ossi has written to the bishops, Bishop Stanislas also have a copy of that paper. He said in a matter of 45 to 50 days, it can be finished. The speedy process means now giving the necessary time and all, 50 when they are apparently invalid. In a question of 50 days or 2 months, if there are personnel and then there is time, cases are less, and then a speedy process it must be. And again this stands good. Even in the ordinary process, you should not exceed a year. That is not changed. That is not changed. Exceed a year to finish your first instance judgment. Even when you are within a year, you have to give the judgment. Yes.
What happens when you don't give a judgment after a year? The case remains valid or?
No. So lapse of time.
That's not in the
Not denied.
See, one of the things is, with regard to the admission of the petition, it is automatically admitted after the specific number of days. The old law said 30 days to admit the petition. You said a reminder, 10 days, over 40 days, case is admitted. But if you do not give the judgment, some judgments come only in heaven. Only in heaven. The person died, this person died. Then afterwards, now Jayalalitha's case also came after the person died only. The judgment also came. Like that, some judicial vicars also may be taking time, but the case is not awaited by merely in this case. So we have to remind, people have to remind, that's all.
It should be automatic judgment within 45 days.
Yes, Father.
I have followed to some extent this judicial process.
Yeah.
Some more light on this term.
You speak about the ordinary process.
Yes.
Judicial. Administrative process means without need of being a judge, you know it. Judicial. The ordinary process is dealt in the code of canon law. There are different stages. For example, I just read the title. The first one is, of course, the petition and the introduction. Okay. The first chapter in this contentious trial is the way. Petition and introducing the suit, writing of the petition. Number 1501 onwards. 1501 onwards. The second stage is summons and intimation of judicial acts. So the respondent has to be summoned, and then now the defender of the bond also is to be notified of the petition. That is the second stage. And the third stage is you decide on what ground the case is to be taken, proceeded. The so-called joinder of the issue. And then the next comes the trial of the issue. In that comes the proofs. What are the different kinds of proofs? First, declaration of parties, documents, and then next the witnesses and their testimony, and then you have the expert's opinion, and then there can be also actually visiting the place with regard to other cases, presumptions. So all these cases, all these things are ways of collecting the proof. When the collection of proof is over, hearing everything is over, then finally the acts have to be published. And then finally, conclusion of the case, you have to publish the acts to the parties, and then to say whether you have anything to add. And the last stage is writing the judgment. So these are the various stages of the judicial process. Huh? Yeah, of course that comes in between. So there is also in the church, by pollution they always wanted to declare the marriage null. In the marriage case, what is important is to find out the truth of the marriage, whether it is valid or not. We are not for that party or that party, the truth. So just as formerly in the canonization cases there was so-called devil's advocate, we have to protect the bond of marriage, bond of sacred ordination. There is one person known as defender of the bond. So this person's role is to protect the bond, defend the bond, argue if anything is there for the validity of that bond. The judge writes the judgment after getting his opinion, after the publication of the acts. Only then the judge will arrive at moral certainty, only then he can declare the marriage invalid. Not metaphysical certainty, not probabilism, but moral certainty. Moral certainty. So these are the different stages of the process. So I summarized it now as fast as that is the thing. You have to have one of the things based on Amoris Laetitia. We wanted to say the Holy Father spoke about this. There are sometimes he uses very strong words. Do not consider people in invalid marriages as excommunicated persons. Excommunicated persons. Do not consider them. You should accompany all the faithful. All the faithful. First of all,